Again, thank you all for being here. We are here to talk about discovering the gift of estate planning. It's holiday season, it's gift giving season. So a lot of people are in that mindset of how can I give a gift to my loved ones that is going to make an impact on their lives? And a lot of people say these days, the times have changed. Like most people, the things they want, they're able to get it themselves. They're able to buy it themselves or obtain it themselves. There's so many ways we can get things for ourselves. And so I want to present estate planning as a gift that you can consider giving, whether it's something that your family will be able to appreciate now or something that they would appreciate in the future. But you can decide how you gift people, whether it's something they receive now or later. So estate planning is one of those ways that you can give a gift that, we'll talk about ways that it can impact your family now. We'll talk about ways that it can impact them later as we continue through. So, like I said before, I like to help people see estate planning as something that can improve their lives and make things better for themselves and their loved ones. And so before we get into the information too much, I just want to make sure that you think about, should you even hang around? Because just because you signed up for this webinar, just because it seemed like a good way to spend your Tuesday evening, this might not be the webinar for you. And so I say that this webinar is for those who are interested in learning how estate planning can make a positive impact on their community, on their families, on themselves. And those who see their lives as a seed to enhance someone else's life. And it's also for people who want to create a legacy that extends beyond their lifetimes. And then on the other hand, this webinar is not for anyone who's just looking for information on how to create their own estate plan. That's not what we're getting into today. We will talk about some of the different documents that you might include in your plan, but you're not going to walk away with a how-to DIY my estate plan. That's something that I discourage a lot because I've seen it from the estate administration perspective. I've seen what happens when people create their own estate plans, and often it's not a good outcome. And we'll talk about that a little bit later. If you're someone who thinks that having a professional do your estate plan is a waste of money, you might not want to hang around, because the way that I approach estate planning naturally, since I am an attorney, it usually involves hiring a professional. And then finally, if you're somebody who's just living for the present and everything that you do is for yourself, if you don't have a long range view toward life, you might not want to participate in this webinar any further, because everything I talk about is about how can we use what we have, use the things that we've acquired during our lifetimes to bless people who come after us and to make an impact that goes beyond ourselves. So, when we're talking about estate planning, again, as I mentioned earlier, I really encourage that we have a shift in our perspective. We don't want to see estate planning as something negative, as something that we dread, as something that we are sad to participate in, but we want to look at it as something that allows us to be a blessing to someone else, to change the world for the better. I recently put out a newsletter article where I talked about how estate planning can help you create the future. Like, think about it. What about if everybody created an estate plan during their lifetime, and then after they were gone, the people who were left behind, well, the people who came after them would benefit from that estate plan that they created. And so I'm like out here in the world, like, y'all, let's all do this, because then we get to help create a better future. Instead of just letting things happen naturally and just whatever happens, we all have an opportunity to create a better future. And if everybody has that mindset, we all get to benefit. And so that's how I like to approach estate planning. I like to say, let's shift our perspective and think, this is a time for me to create this vision for how I want the future to look, whether it's for my family or whether it's for my community. What kind of future can I help create by doing an estate plan? And I have this quote here that I think is helpful, that when we focus on things from a positive perspective, then it allows us to have a more hopeful outlook. And then we believe that we can do something great, and thus we actually do something great. So that's the essence of that quote, that the way we think about things is going to produce a certain outcome. And so that's why I like to talk about estate planning, because I really see the potential in making the world a better place if everybody approached estate planning from this perspective. And so y'all kind of heard a little bit about why I did this presentation, what my vision is for people doing their estate planning. And I figured that I'll go ahead and tell y'all a little bit more about myself, so that you know who you're talking to today. Some of you know me, some of you know me very well, some of you know me a little bit, and some of you don't know me at all. So here's just a little background information. I live in Macon, Georgia with my husband and my 2 daughters. I graduated from Mercer here in Macon, and then I went to law school at Duke Law School and graduated from there. I've been practicing for almost 15 years. I had 15, but it's not all the way 15. It's almost 15 years that I've been practicing law, which is kind of crazy to think about. And I've had a focus on estate planning, probate, heirs property, and farm business and succession planning from one degree to the other for 7 or 8 years. I've been doing this for quite some time. And when I sat down and actually started doing the numbers, I was surprised at myself to see how long I've been doing this stuff. As you can say, you can say I've been around the block a little bit with it when it comes to estate planning, probate. I think I haven't seen it all, but I've seen a whole lot. I promise you that. I don't know. I'm not gonna go into it now, but I've seen a lot, like crazy stuff that you don't really think about, but it comes up when you're doing this work. I'm a highly sought after speaker and presenter on these topics. I've spoken at many churches around the state of Georgia. I've gone to different parts of the country to talk about estate planning and heirs property to some degree. And I love doing this work. I love talking about these topics: heirs property, estate planning, probate, all of that stuff. And the reason why is because I see the potential that if we handle these areas properly, then we can help people to generate wealth and to improve their lives and the lives of the people who come after them. And so all of this goes into helping people to improve their own lives. And I also am the owner and CEO of McClendon Law and Consulting in Macon, Georgia. And so a little bit about McClendon Law and Consulting. We provide heirs property, estate planning, and probate legal services to help farmers, landowners, and other legacy-driven individuals build wealth, increase their income, and secure their legacies. So I do like to work specifically with farmers and landowners, but it's definitely not exclusive. If you are a person who wants to leave a legacy and that's like what drives your goals when you're doing your estate planning, then I would love to work with you. I do have to be clear that I do practice. I'm licensed in the state of Georgia currently. So you do have to be a Georgia resident in order to do estate planning with me. However, I offer some other services, particularly with the education and things like that, that can be applicable in other states. So as a law firm, we help our clients to, particularly when it comes to estate planning, we help our clients to create a plan to transition their assets that accounts for their probate assets and their non-probate assets. And so when I say probate assets and non-probate assets, what I'm saying is there are some kinds of property that would have to go through probate court if you had a will or if you didn't have a trust as part of your estate plan. And then there's some that probate court doesn't really address it. So that would be like life insurance policies, retirement plans. Sometimes you can title your real estate so that it does not have to go through your estate. So anything that would not pass through your estate is a non-probate asset. And so my firm, when we do estate planning, we help you with things that would go through probate, but we also want to help you plan for things that would not go through probate. And so definitely something, if y'all have questions about it later, you can bring that up when we have the Q&A time at the end. We also help our clients to provide their families with guidance to ensure that the estate administration process is as smooth and stress-free as possible. And I'm real notorious. I find myself often using terms and phrases that I should explain a little bit more. And so I want to take a moment to talk about estate administration. So when someone, actually, I'm gonna do that in the next couple of slides. I actually have a slide that talks about it. So let me not get ahead of myself. But we also help our clients to transition unproductive property to income producing assets so that they can leave more to their loved ones. So I really enjoy when I have a client who comes to me and they might have real estate, might be a house, it might be land, they might have a business that it's doing what it's doing, but it could be doing more. And I love when I can help my clients to figure out ways that they can use their assets to generate more income, to create more wealth for themselves and the people who come after them. And the reason why I like that so much is because it's not just helping their family after they're gone, but it's helping the person right now. And in addition to that, they're able to leave their loved ones more than they would have left them without dealing with these things. Because for example, you might have a house that has the potential to be a rental property, but you need to deal with stuff like probate, or you might need to do some things to clear up the title. But once we do all of that stuff, then you have an asset that you can rent out to someone, get a monthly income, and then that income that you acquire over time will help you to improve your wealth. And then later you'll have something more to leave to your loved ones. So I really enjoy those kind of situations where I can help my clients to take what they already have and to increase the value so that it's better for them and for their family. So we talked a little bit about me. We talked a little bit about my firm and what we do for our clients. And so now I want to talk about estate planning. And before we get into estate planning, we have to first make sure we're all on the same page about what is an estate. So an estate is all of the money and property that a person owns, particularly at the time of their death. So anything that a person owns when they die, that becomes part of their estate. And we have to figure out, what do we do with their estate? What do we do with that property? If we pre-plan, which is what we're talking about today, we get to control what happens to our estate after we're gone. But if we don't pre-plan, then state law controls that. And our heirs, our family members are going to have to figure out how to navigate that process of deciding how our estate will be handled. I mentioned earlier the phrase estate administration. Estate administration is the process that you take, the process that you will follow in order to take a person's estate assets and put it into the ownership or the control of the people they've left behind. So let's say that someone has died and they had a house, they had some bank accounts, they had a vehicle. That property is going to be part of their estate. And in order to transfer that property to their children or their spouse or whoever they've left behind, there has to be a process of estate administration. We also call it probate, but I like to use estate administration because probate kind of suggests that there's a will involved. Estate administration is like the umbrella term that includes situations when a person has a will and also includes situations when a person does not have a will. So I'm hoping that me explaining this is helpful. If y'all have questions, if I'm saying something and it's still not making sense, please feel free to put them in the chat. And then if I see a question in the chat, I'll try to address it now if it makes sense, or we'll address it later. And definitely, if y'all ever get to a point where you can't hear me, if I'm not clear or my microphone goes out, please let me know before it gets too late. So let me know that as well. So we talked about an estate, we talked about estate administration, and we touched on estate planning. But an estate plan is a person's written instructions for how their money and their property should be distributed after they die. It also includes caring and providing for their minor children or other individuals that might be in their care. So for example, if they're caring for an elderly parent or a disabled brother or sister, then they would need to say, if I'm not able to care for this person anymore, who would take the role after I do? It also involves making healthcare and financial decisions for the person while they're still alive, but unable to handle their own affairs. So that's a situation where someone may be sick, or they may have had an accident, or some kind of situation has arisen, and now they are not able to manage their own money. They're not able to handle their own affairs. They need somebody who can make decisions for them and handle business for them. So estate planning helps you to cover those scenarios as well. The things that we do during the estate planning process, it usually includes creating a plan for passing on your personal assets, planning for in the event of incapacity, planning for loved ones who depend on you, and also planning for long-term care. More and more these days, people are living longer, but in living longer, they're not necessarily living healthier. And so it's becoming more likely that adults will at some point in their lives require long-term care or someone who can they'll need the finances to have someone to care for them either in a nursing home or at home. And so planning for long-term care is part of that process of estate planning as well. So we'll talk a little bit more about it later. But if you are a land or a business owner, your plan might include a little bit more than the items I just mentioned before. So this is going to also include passing on your business assets. So I always tell people estate planning usually involves your personal assets, but if you're a business owner, you also have to deal with those business assets. And you also have to figure out who's going to run your company after you're gone. If you have a company that you want to continue after you want to make sure you have a plan for passing on that operation. And then you want to pass on the know-how. Make sure that the people who come after you know how to run the business so that they can continue to run that business. And this is something that is near and dear to my heart as a business owner and as someone whose firm works with business owners. I really want business owners to think about this. I don't want you creating a business that's just for you and you're making as much money as you can and that's it. But actually creating a business that you can pass to the next generation, that you can sell, and then the money is used to help the people who come after you. To have your business to be a long-term asset. And the way you do that is by putting a plan in place early on so that you're not trying to figure things out at the last minute. So here are some of the things that go into an estate plan. We have a will, and another option would be a trust. Some plans, if you have a trust, you're going to usually have a trust and a will, and that will is used to put anything into your trust that may have gotten left out. And I'll explain a little bit more later. But usually it's going to be either a will-based plan or a trust-based plan. If you have a business entity, you want to make sure that you have something like a LLC, LLP, a corporation. And when you create those entities, you want to have governing documents with them. So if you have an LLC, you need an operating agreement. And that operating agreement will deal with situations. It should, let me not say will, because I've seen some that don't. It should deal with situations such as if the business owner becomes incapacitated or when the business owner dies. You want to make sure you make it very clear in those documents what happens so that the company can continue on beyond the business owner. Your estate plan would also include advance directives for healthcare, and that is a document that you would use to tell your doctors, tell your healthcare professionals who you would want to make medical decisions for you if you became unable to make those decisions. You also want to put, depending on what your preferences are, if you're someone who has very strong preferences about end-of-life decisions, you would want to include those in your advance directive for healthcare as well. A financial power of attorney allows you to put somebody over your finances to make financial decisions for you if you ever got to a place where you're not able to do that for yourself. And then it also might include life insurance and other benefits, and then funeral arrangements, prepaying funeral services. A lot of people talk about, or like if you talk to people in this arena, they talk about how you can plan your funeral now, pay for it now, and then whenever you're gone in the future, that plan is still applicable and you can get a nice funeral for the price that it would have been in 2023. And I saw this happen specifically in my husband's family, where his grandfather paid for the funeral for himself and for his wife like in the 90s or something, like a long time ago. And when she passed in the 2000s, like the cost of the funeral went up astronomically, but that plan covered that expense. Regardless of how much the actual prices were, that plan locked in the rates from the 90s. And so my husband's family didn't have to pay anything to get her buried. It just put that plan in motion and everything was taken care of. So sometimes estate planning can include that as well, because it can be helpful to the family later on. When you're doing your estate planning, what you're wanting to do is provide clear instructions for the people who will be handling your affairs for you. Make it very clear what you're wanting to do, and also to try to make it as easy as possible for them. If you talk to anybody who's had to handle the affairs of a loved one who has died, it's very stressful just because you're mourning and everybody has questions for you. Everybody's saying, well, what do you want to do about that? What do you want to do about that? And a lot of questions that person has never thought about. And even if they have, they don't know what their loved one would have wanted, or how, where they kept their papers, or what kind of things they had set up. And so estate planning is all about making it easier for your family. So since I'm not going to talk about financial power of attorney and healthcare directives that much later on, I did want to make a couple of points. One, with the financial power of attorney, a lot of people don't realize how valuable that document can be. Usually if you get one, you can actually find one online, and it's the same form I use. I'll be honest with you, it's the same form I use. It's online. You can do it for free. Or you might hire an attorney to do it, and it's probably going to be relatively inexpensive to get done. But that little document can make a world of difference. I had a situation early on in the beginning of this law practice where I had a client whose spouse became ill very suddenly. It was very unexpected. And they were in a position where they could not communicate to anybody about anything. And so this person's spouse was trying to access bank accounts, was trying to pay bills and trying to handle business. But because the person who had gotten sick did not have a financial power of attorney, they had to go to probate court and open up a conservatorship. In this particular case, we were not even able to get to that point because the person passed away before it became needed, but before we were able to get the guardianship and conservatorship. But going to court to get a conservatorship can cost thousands of dollars, because you have to pay for first the court filing fees. Then the court is going to bring on a person, an attorney, who is going to just kind of make sure everything's done properly. Then the person who is disabled, they're going to also have their own attorney. So you'll have this attorney that's there to make sure everything's handled properly. Then you'll have the attorney who actually represents the disabled person. And then you might have an attorney that represents the person who's trying to get guardianship or conservatorship over them, because they're trying to make sure their loved one's taken care of. So you got to pay for 3 lawyers. You also got to pay for doctors to evaluate the person, which is an extra fee. And then there's some other little things that go in there. So it's several $1,000s sometimes to do a guardianship or conservatorship. And then conservatorships are just so complex because you have to put all this financial information in. And so I'm saying all that to say that little power of attorney that seems like a insignificant thing can make a world of difference. If you have one in place, it allows your family to get in there and handle your business quickly without having to go through all kinds of hoops in order to handle business for you. And if you ask anybody who's had a loved one in the hospital, you'll understand the importance of a financial power of attorney and an advance directive for healthcare. Because when you can't make decisions for your loved one because you don't have legal authority to do so, it's really stressful. And nobody wants to be in that position. So I just wanted to say that even though those 2 documents may seem kind of small, and sometimes even as attorneys, we're like, oh yeah, we can just throw in a financial power of attorney, healthcare directive, but they are very critical and they can help save the family a lot of money. So we're going to talk a little bit more in depth about wills and then trusts as well. And as I'm transitioning to these slides, y'all good? Y'all let me know in the chat. We good. We not sleep. We're still awake. We following, we tracking. Let me know. I like to kind of get a little engagement from the people who are participating. Right. All right. My slide will go. Okay. So talking about a will, what does a will allow you to do? So before I even get into that, I should tell you what a will is. I'm not going to assume everyone knows what a will is. A will is a written document here in Georgia, I'll say, because I think in Louisiana they have like a holographic will or something. We don't have that here in Georgia, and most states don't, but Louisiana is its own country, seems like, when it comes to the laws that they have. So a will is a written document that allows you to say what happens to your property after you die. It also allows you to nominate an executor, and I have these things here. Nominate an executor who can be over your estate, so you get to decide who handles your estate for you. If you want to use your will to fund a trust, then that can be done, and we'll talk a little bit more about that in a few minutes. You also get to nominate a guardian or trustee for minor children. So like if you have children who are underage, like I do, I have minor children, you want to make sure that if something happened to you, that they have someone who can legally take care of them. The court would appoint someone for you, but you know, when it comes to your kids or if you have a disabled loved one, you don't want just the court deciding who's going to be the best person to take care of them. So it's very important that you nominate a guardian and a trustee for any minor children, and then also for any disabled adults that are in your care. And then also, if you are a person who has had a charity or any kind of philanthropy that you like doing while you were living, you can continue that charitable giving through your estate planning. All right, so we talked about distributing your assets. When we first got started, I talked about the difference between probate assets and non-probate assets. Your will allows you to distribute your probate assets. So this might be anything, this is anything that's in your name. So it could be a house, a land, or other real estate. If those assets don't have a survivorship provision in the deeds, then they would be part of your estate. So if you bought a house and that house is you're listed as the grantee of that house, the person who bought the house, then your will more than likely can control your house or other real estate. Any bank accounts that you have in your name, you can have your will to control those assets, to say after I die, I want my brother to get 3,000, my sister to get 3,000, I want my cousin to get 500, I want my kids to get 10,000. You get to put that in your will as well. And then if you have personal property, vehicles, jewelry, furniture, you can also address that in your will. And you can do it specifically where you say, like I did, this much money to this person, this much money to that person, my house that I live in to this person. Or you can generally say, I want all of my money to go to be split between these particular individuals, or any property that I have, I want it to be split between these individuals. When it comes to personal property, that can be okay. Personal property money, you can say all my personal property, vehicles, jewelry. Well, vehicles is probably not the best example, but like jewelry, clothing, furniture, all that stuff, that just goes to my children. Y'all split it up. Y'all figure out what y'all want, what y'all don't want, and split it up between yourselves, and then everything else you donated to Goodwill, or you'll do an estate sale and split the money. But if it's real estate, it's not really a great idea to say my house goes to my 4 children. We don't want to do that, because then one child wants to live in the house, one child wants to sell the house, one child wants to rent the house, and the other one, nobody heard from them in 30 years. So we don't know what they want to do. We don't want to leave that one piece of property to all those people. And so there are ways that you can set your estate up so that you can have a plan that makes more sense, because you don't want to put your family in a situation where they don't know what to do. Your will does not affect life insurance policies, pensions, retirement benefits, or anything like that, because those are those non-probate assets that I talked about. And unless your estate is listed as a beneficiary, or in some cases, if like you have a life insurance policy, you leave your policy to a particular person. If that person is deceased, then in some situations that might become part of your estate. Depends on timing and all of that. I got a story that I'll tell later that um it was just interesting, so I'm looking forward to telling it. It was not a positive story, but it's an interesting, good teaching story. um I might have to get a sip of tea every now and then to keep myself from getting a sore throat. um So you also get to nominate an executor to handle your estate. Your executor is the person who's appointed to carry out the terms of your will. I always recommend you have a backup executor and probably another backup. Like I like to have a primary and a backup and then a backup to the backup, because you just never know who's going to be around when it's time to probate your estate. Select somebody that you trust, and their job is to pay off debts owed by the decedent, distribute remaining assets to the beneficiaries. If there are any court proceedings, then they can represent the interests of an estate. And I'll give an example there. I've had a few situations where personal injury attorneys have contacted me and asked for help because they have a settlement and they need an estate representative to receive the settlement. So it might have been a person who got into a car accident and then they died from that accident and they were entitled to money, but you can't sue the person if you're deceased. So you need an estate and an estate representative to file that suit for you. And so there's been several times where I've been asked to open an estate for someone so that their family could sue someone who owed their loved one money. And then also your executor can carry on any business that you have until those responsibilities can be transferred to someone else permanently. So, with my law firm, it's not a great example because we're required to have lawyers that we assign to have responsibility over our firm if something happens to us. But just for an illustration, if I had an executor, then my executor would be able to get into my law firm and at least find a document so that they can find out who the lawyer is who's supposed to take over the firm or whatever needs to happen. The executor can come in there, handle the business to the extent they can. Nobody but a lawyer can handle a lawyer's business, but there might be people to call or things that where someone needs to be put in place, and your executor can do that for you. I do want to say here, just for anybody it applies to, that an executor or an estate administrator, their job is not a lifetime appointment. They're supposed to get in there, handle the business, get out as quickly as possible. But I've had too many situations where someone serves as the executor or the administrator for years. And it just causes a lot of problems, a lot of confusion and lack of clarity. So your job is to get in there, handle the business, make sure the assets get to the heirs, and move on out of there. So I just want to make that little point. Do want to emphasize that with the will, probate is required. You have to probate the will in order for the will to control the property. And I specifically say that because it's different from a trust, which we'll talk about in a minute, where probate is usually not required for a trust. So let's talk about trusts. What is a trust? And this is a hot topic these days because there's folks on TikTok, I guess, and Instagram. I'm not on TikTok. I am on Instagram, but there are people out there on the internet telling everybody that they need a trust for generational wealth and make sure you do this because this is what the wealthy do. In some cases, it makes sense, but in some cases, it does not. And a lot of times people don't even know what a trust is. They just heard it's something they need. And so I really like to spend some time on this because I want to make sure everybody knows what a trust is. A trust is a legal arrangement in which one party takes responsibility for the property or money of I left my little phrase out there, but one person takes the responsibility for property or money of another person, and they manage it for the benefit of one or more parties. And I'll explain it in a little visual in a moment. There are many types of trusts, and it depends on your goals as to which trust you should use. The two main categories, one is revocable, the other is irrevocable. Those are the two categories. Revocable trusts are the ones that we usually use as a substitute for a will in an estate plan. It allows you to create this legal entity that you put all your property in there. And as long as you are alive and in good health, you are the trustee of that trust. You manage it. You use your property just like you would any other time, as if it was in your actual name. If you became incapacitated, you're not able to handle your own affairs, you're still living, but you can't handle your own business, your trust automatically has a provision in there that allows a successor trustee to step in, and they can seamlessly come in and take over the management of your property. Make sure that your bills are paid. Make sure that you're taken care of. You have everything you need financially. Then after you die, either the same person or another person can step in seamlessly and take over your assets to make sure that it either is managed properly for a particular period of time, or that it goes to the people that you named in your trust as beneficiaries. So that's a revocable trust. An irrevocable trust is one, and let me go back and say that a revocable trust can be revoked. While you're living, and if you're in good health, you can cancel the trust and say, I no longer want the trust. Or you can say, I want to change the trust in various ways. You can do that throughout your life, as long as you're in good mental health and able to make those decisions. An irrevocable trust is different, because once you create it, you can't really change it. You can't really say, I'm going to end this trust. There are some loopholes to that a good lawyer can help you to understand. And, you could talk to me. I'm a good lawyer, but you could talk to me or another good lawyer about how to either change the trust. There are things that they can put in place to allow someone else to change the trust for you if that's needed, or allows someone to terminate the trust if that's needed. But the key thing is that revocable trust can be changed or destroyed easily, relatively easy. You might want to get your lawyer to do it, but it's not something that requires a whole lot of extra steps. An irrevocable trust is a lot harder to do that, and in some cases, it's just not possible. So it's very important to keep those things in mind. And the goals of a revocable trust versus irrevocable, they have different goals. And so I'm not going to try to explain all of it here, but what I will say is that if you are looking to have a trust, you want to talk with your attorney about, should I do revocable? Should I do irrevocable? If I do irrevocable, what are the goals of that trust, and what different trusts might make more sense for my situation? Under the category of revocable, irrevocable trusts, there are, and actually all of there's a special needs trust, there's a charitable trust. Those fall under irrevocable trusts. And I have inter vivos versus testamentary. An inter vivos trust is a trust that you create while you're living. A testamentary trust is a trust that is created through your will. So you might have a will that says, when I die, I want my property to go to these people. It has to go through probate court. Or you can say, when I die, I want my property to go to these particular trusts. So you might say, if I have minor children, I want their property to go to a trust. I don't want it to go to them. Or if I have a disabled loved one, I don't want their property to go directly to them. I want it to go through their trust. You can do that so that the trust is not existing while you're living, but after you die, someone creates the trust so that the property can be put in there for people who are not able to receive the property outright. And so here's a little visual to explain how a trust works. I hope that it's still helpful. Sometimes I think I need to kind of modify it a little bit, but we have here the trust property. And y'all let me know, put in the chat if this is confusing or if it makes sense. That'll help me for the future. So this is the trust property. It could be any asset. It could be a house, money. It can be, investment accounts. It can be anything that would be considered an asset. You take that trust property, and the person who owns the property is called the settlor or the trustor, or in some places they might call it the trust maker. But those are different words to describe the person who originally owned the property and decided that they wanted to create a trust. So they create the trust. It's not really a box. It's just like a concept. I always tell people it's in the air somewhere. It's a trust. But that trust is described by a trust document or a trust agreement or a trust instrument. That's the legal contract that creates this trust. And once you create that trust, you say, I want this person or these people or this institution, this company to be the trustee. And the trustee's job is to take the property from the settlor, the trustor, the trust maker, to take custody of the property, and they then manage it on behalf of the beneficiaries who are here in this upper right-hand corner. So these are the people who would benefit from the trust. The trustee's job is to manage it for the beneficiaries, and the settlor is the person who owned the property in the first place and is putting it all into motion. Just to make it a little fun. With a revocable trust, the settlor, the trustee, and the beneficiary can be the same person, because you're basically creating a trust for your own benefit and you're the one who's managing it. But it's also set up so that if for some reason you're not able to manage it, then you'll have your successor trustee come into place. Or after you die, you can't be a beneficiary. So then you have some other people who would be beneficiaries of the trust. So I hope that little visual helps. Reasons you want to include a trust in your estate plan. There are various reasons. There's privacy. You might have a minor or disabled beneficiary. Spendthrift beneficiaries, those are people who either can't handle their money well or they have a lot of people they owe money to. Asset protection, death tax planning, that could be estate taxes, gift taxes. Can't remember the other, generation skipping tax. GS. I'm missing an S, but generation skipping tax, and there's something else in there. Hold and manage property for multiple people, hold and manage family property, or the automatic transfer of property upon your death or disability. So there's a lot of reasons that you might have a trust. Let's see if the little diagram was clear. What happens if you die without a solid estate plan, either created by a will or a trust? Your possessions will be distributed to your heirs at law, and that's going to be according to state law to see who your heirs are. If you know, for an example, if you're in Georgia, your heirs would be your spouse and children if you have a spouse and children. If you don't have a spouse, it goes to your children. If you don't have children, it goes to your spouse. If you don't have a spouse or children, then next in line, I think, are your parents. And then if your parents aren't here, it might be your grandparents. If your grandparents aren't here, it's going to be your brothers and sisters. And so the state has a plan for you if you don't have a plan for yourself. But you don't really want to go with the state's plan. A judge is going to appoint someone to administer your estate. A judge decides who takes custody of your minor children if you have them, and a judge would appoint someone to manage any assets or money that you leave to children or to people who are disabled. A judge has to decide all of that. And so it's good to have an estate plan in place so that you, okay, why you freeze on me? There you go. So that you are in the driver's seat. You get to decide in advance how things will go. That burden is taken off of your family, and you get to maximize the value of the assets that you pass on. It allows you to leave a legacy that outlives you when you have an estate plan. And I like to encourage people to look at estate planning as a gift. And that's like where we came up with the whole estate planning is a gift concept, discovering the gift in estate planning. Gift is an acronym, and we'll get into that now. Some people are curious before, but here you get the secret as to what gift stands for. Gift is to help us understand what we can do to do estate planning, but to make the estate planning process easier and break it down a little bit. So you want to establish your goals. Goals is the G. You want to create an inventory, select your fiduciaries, and assemble your team of advisors. So your goals. I like to use Stephen Covey's quote, begin with the end in mind. You want to cast a vision. Your estate plan allows you to cast a vision that your beneficiaries can use to pick up the torch and and keep running. Pick up the torch where you leave off and keep running. And I like people to really think very vividly. If I could have everything my way, I don't have any laws or any barriers or any family members that get on my nerves. In the process, I get to decide the vision that I want to create. What legacy do I want to live with what I have? I like this to be a creative process where your juices get flowing, because then people start getting excited about it, like, oh, I could do this and I could do that. And one way I help people to get themselves out of the picture without getting all sad is to say, hey, 100 years from now, what impact would you want your estate plan to have? And that way, like, nobody really expects to be around in 100 years if they're like an adult 100 years, unless they're like 20. I don't know. People not really thinking like, I'm gonna be here 100 years from now. Not everybody. Maybe we need to start doing 150 years. People living longer. But 150 years in the future, how would you want things to be? This house, like, who would have it? What will go on? Like, that helps you to kind of come up with a vision for your property. Let your goals lead your estate planning. Creating an inventory, you got to know what you own in order for you to be able to create a plan to pass it on. So it might be real property, cash, bank accounts, investment accounts. If you're a farmer, farm equipment, vehicles, valuable personal property, business interests. Create an inventory. Put everything on there, including your family heirs property. I'm saying that because I have done a few estate plans where we get to the end and they're like, yeah, oh, you do heirs property? Oh, yeah, we own some land. And I'm like, why you didn't tell me about that land when we're doing the inventory for your estate plan? So I want to make sure you include that land. Be overly inclusive. Tell your attorney everything, and then let them tell you, oh, we don't have to include that. Don't rule it out first, because that can cause you to not have a complete plan. Select your fiduciaries. Your fiduciaries are the people who will help you carry out your plan. That would be your executor, your trustees, legal guardians for minor children, legal guardians or conservator in case you become incapacitated, and then your agents for your financial power of attorney, your healthcare directive. These are people who can help make decisions for you, or who will carry out your wishes in your plan. And finally, you want to assemble your team of advisors. Everybody, this estate planning is not something that you need to do on your own. I always tell people, they say, I want to be wealthy. I want to create generational wealth. I'm like, well, you need to do what the wealthy people do. They hire advisors because they know that they don't know everything. So you may not need all of these people, or you may need all these people, or you may need one or two, but you want to make sure you have, if you need them, attorneys, financial advisors, insurance agents, land use experts if you own land, business consultants. Use the people that you need to help you create the plan that's going to make the most sense for you. Because there are things, all these people on this list, they have their area of expertise, their zone of genius. They're not going to be able to do it all. Me as an attorney, with the kind of background I have, I can say, oh, you probably need to get you an agricultural consultant. You might need to get you a forestry consultant. You might want to talk to a life insurance agent, or you might want to talk to a CPA who specializes in high net worth estates. I can like point you in a direction, but don't ask me to help you to figure out a financial plan. Like that's way outside of my expertise. So you need a team, and depending on where you are financially, what your wealth looks like now, where you're trying to go, you may need all of these people, or you may need a select few. I see I talked too much at the beginning. Now I'm running out of time, but what I'm gonna do is just try to get through the slides pretty quickly, and then if people want to ask questions after 8 o'clock, then I can hang around for a few minutes if people have questions. I want you to view estate planning as a gift. We talked about that throughout this time, because estate planning is the key to leaving a legacy that matters beyond your lifetime. So estate planning is a gift for your family. We talked a lot about that. Like, to think about being someone who gets to start life with more than what the person who came before them had. It's like each person can make it so that the next generation is a little bit further along in the process. perhaps, you know, I always tell people, usually your estate plan is going to be for your grandchildren or your great grandchildren, because your children, hopefully when you're gone, like I expect my kids to already have something, because I plan on them being old too when it's time for me to go. But my grandchildren, my great grandchildren, I want them to be able to benefit from whatever I would leave them. So if I leave money, they don't have to go borrow from a bank. They can use the inheritance that they have to start a business or go to college, or you know, go on the trip of a lifetime, whatever it might be. Take some time off from work to travel the world. Whatever you want to do for your family, estate planning is a gift for them in the future, but it also is a gift for them now. We'll talk about that in just a moment. It's a gift for your community. Have you ever gone to a neighborhood and it's like falling apart and you're just like, oh my gosh, like what happened here? Did people ever live here? Yes, people used to live there. People own houses there. But when they died, there was no plan in place for who would take that house over after they were gone. And so you end up with heirs property. You end up with property that sits in an estate for decades, and then nobody can get control over it. Nobody knows how to contact the mortgage company, because the mortgage company won't talk to you unless you're the estate representative. And so the property sits there and the community suffers as a result. So estate planning is a gift for your community. And I also say it's a gift for you as well. It's a gift you get to enjoy now. Because like I mentioned, when you think about estate planning and really invest into it, it helps you to see it helps you to like think about your life differently, because you're not just like going day to day and doing things, going through the routine. You're actually able to think, okay, where do I really want to go? What do I want to leave my children? What do I want to leave my grandchildren? Am I on track? Do I need to make some changes to get on track? So it helps you to improve your life, because now you're thinking about the future and you're thinking, how can I improve now? What steps can I take now to make the future what I really want it to be? So I like to see estate planning as a gift in that way. And so, you know, real quick, can I do it myself? Yes, you can, but I don't recommend it. It's too many pitfalls, and we didn't get to touch on a lot of them, but I just had a few situations that where it was, you know, there was a not having an attorney to help you think through all of these issues created bad situations for clients that I've worked with. The situation that I'll go into, I probably won't get into all of them, but one that really I'll never forget it. It like governs how I do everything now as an estate planning attorney. Had a situation where someone died. They didn't own anything when they died, and so they wouldn't have had an estate. But someone died. How did it go? Can't remember how it went. But basically what happened is this person inherited something from another loved one right before they died, like a few days before they died. And so they didn't own anything at first, but because this other person died and left them something, and then they subsequently died, now they have an estate. It just so happened that this particular person had not only the loved one that left them the property, they had them as one of their heirs. They also had some other children who had died before them, and now their grandchildren were their heirs. So we ended up with an estate where we had to bring in all these people. We had grandchildren who were minors, and we had to get guardians at litem appointed to represent their interests. Then we had like one of the heirs who they were a minor and they were getting too much money. So what we had to do was open a conservatorship for them. And there were all these different court processes that had to happen that had the potential to cost this family thousands of dollars, like huge amounts of money. It actually didn't for different reasons, but it could have very easily if the circumstances were right. And so now I'm always like encouraging people, think about minor children. Even if you don't have minor children, you never know, they could become part of your estate if someone that you leave something to dies before you and then they had minor children. So you really got to think through all of those different scenarios. When you choose an attorney, you want an estate planning attorney. All attorneys are not created equal. Y'all screenshot this so y'all can have these tips for selecting an attorney in the future. Y'all made it. All right. Pitfalls to avoid. These are some of the things you want to avoid when you're doing your estate plan. We kind of touched on a few of them throughout, but I just like to have it all on one slide. And then we talked about the different types of plans. I talked about a trust-based plan, a will-based plan. And if y'all have questions about this, we can go back over it later, but I'm trying to stay as close to the hour as possible. I'm a little over, but we're gonna get to the end just in case people have to leave. And so here's the process for estate planning, particularly with my firm, but any firm, I think it would be relatively similar. For my firm, we call it a clarity call. Other places might call it a consultation, but basically you will schedule time to meet with the attorney to talk with them about your assets, what you own, make sure that you kind of know which plan that you want to go with. You're usually going to complete a very detailed intake form where you'll put a lot of information on there, the stuff we talked about, your goals, the people who you trust to carry out your wishes, your fiduciaries, your inventory, what do you own? You're going to put all that stuff in there, and even your advisors, your team of advisors. Sometimes your estate planning attorney wants to know who else is touching your assets and who else is involved in the process. You want to select the plan. During that consultation, you'll probably select the plan with your attorney, and then you'll have another meeting where you'll design your plan. After you design the plan, then you're going to review it with your attorney, and then you'll sign it and make it official. And somebody asked if we'll cover this information at a later time. I probably am going to do a similar presentation once a month, so you can always tune in the future to get the information. And so when we talked about estate planning being a gift, the whole estate planning process is a gift to you. What you do through your estate plan is a gift to your loved ones, your community. But I have a special now, since we're in the holiday season, where you can give the gift of estate planning. I meant to have a slide on here where I mentioned how a clarity call with me is $400 when it comes to estate planning, and it's a time we will go through your intake form and we'll talk through how we would recommend that you outline your plan, the different things that you want to account for. We'll talk about those items and get you started on drafting your estate plan. Like I mentioned, it's $400 usually, but during this holiday season, we have two specials. One is buy one, get one, where you can buy one clarity call for the price for $400, but then you get two. So you can buy one and then you can get it for yourself. You schedule your own appointment, and then you can gift it to someone else after you schedule your appointment, so that you can buy one for yourself and gift one to someone else. And then we also have it where if you already have your estate planning, or you're not interested, you live in another state, whatever it might be, you can just buy a gift certificate for someone to schedule a clarity call. And that gift certificate is $300. So you would be saving $100. And of course, the person you're gifting the clarity call to, they're not paying anything. They get started for free. And then from there, they can take it on their own. But I want to tell you all about these gift certificates. And the next slide here, if you scan this QR code, then you can get to the page where you can buy the gift certificates, or I'm going to put the link in the chat. If you're in a position where it's easier for you to click, then you can click that link there to purchase the gift certificates. You can do it for yourself or a loved one. You can buy as many as you want. Hey, get it for the whole family. Get it for all your coworkers. Everybody needs an estate plan. So if you're feeling real generous, this is a way to help you with your Christmas gift shopping, to help people to get started on their estate planning. So here's my contact information, my phone number, my website. Take a look at the website. I'm proud of it. The person who did it, I think they did a great job. So take a look at the website. Email us at info@mcclendonlawoffice.com if you have any questions. We're on social media, Facebook, Instagram. I think those are only two other than YouTube, at McClendon Law GA. And we do have a YouTube page. It's currently called the YouTube channel. It's currently called the Family Land Law Firm. So if you go on YouTube and you search for Family Land Law Firm, you should see me. I'm usually like doing some kind of shenanigans, talking to y'all about stuff like this. So you can definitely check out the YouTube page as well. So I'm gonna let that be it in terms of the official content. If y'all have questions, please put them in the chat. Or if you want to, you can unmute yourself at some point if you want. If you know how to raise your hand, you can do that. But put your questions here. I'll hang around for a little bit to answer them. If somebody wants me to go back to a slide, let me know. I can do that as well. So I just want to say thank y'all so much for being here. I really appreciate the opportunity to talk with you. So if you gotta go, feel free to go. If you want to hang around, hang around. I see I had a question in the chat. Well, I put the YouTube channel in the chat. I'm gonna try to do that. I'm gonna see if I can do that while I am talking to y'all. So here.
So when you do the clarity call, do you do those in person?
So
Or
they're usually by Zoom, but if the person wants to do it in person, then I'm happy to do it in person.
okay.
And so if they don't mind coming to Macon, then we can definitely do it in person if that's preferred.
Okay.
Mm-hmm. And I see, let's see. Somebody said, would the presentation be able to be read over? Maybe to go back to a different slide. Is that what you're wanting to go back a few slides? But I know I kind of rushed through the end. Okay, so I'll go back a little bit. Does anybody else have any questions while I get that? Somebody said, how often should a person update their estate plan? So I tell people that they should review their plan at least once a year, no more than every 3 years. With my firm, we offer every 3 years we allow people to schedule a call to review their estate plan if they have questions with us. In terms of reviewing of updating it, if you have someone that you have provided for in your plan who has died, or if circumstances have changed, like you may have decided that you wanted someone to be your executor, but then later they became incapacitated or they just get on your nerves and you don't want them to do it anymore, then you might want to update your plan then. But if everything's up to date, you really don't have to update it. But sometimes it can be good to review it with an attorney because then they can help you to see things that you might not see on your own, to see if it's something that they would recommend that you update. So some of the things that might impact your plan, if you have, like let's say you start with a certain amount of assets, and then in the future your assets have grown in value, you might get to a place where you have to think about tax planning, because you might have a certain amount of money that kept you under the taxable threshold, but then either the law has changed or your assets have grown so much that now you need to create you need to do something else in your plan to make sure that your assets are protected and get to the right people. Or if you have minor children now and then later they're adults, things will change. You're not as concerned about making sure they have a trustee or making sure that their property doesn't get left to them directly. You might be willing to allow them to have full control of their property. So those are reasons why you might want to update it. But I also would say that as an attorney, when I do my plans, I try to account for different changes. So even a situation where your child is a minor and then they become an adult, I want it to grow with them. And so we have a provision that we can put in there to say that when they become an adult, they can become a co-trustee of their trust. And then slowly the authority will go to them as they get older. Or you can say they get part of it now, part of it later, and then part of it at another age. Those are things you can put in place to say, I might have a 10-year-old now, but if this is needed when I have a 22-year-old, I would want them to be able to get this much of the trust assets. So there's
Okay.
different things you can do to kind of plan ahead.
Okay, so that's the reason why I was asking you if we could do it in person versus over Zoom. I already have a will, but it is so old and it is so out of date. Um, so rather, I don't know how I would allow how I could, share what I already have with you to move forward. That's what I was wondering if you only did Zoom calls.
Yeah, so different options. Like you can scan it in and we can look over it by Zoom. But again, like I said, it could be done in person too. Just to like make sure that everything's covered and you can like point things out that you want to point out. So we try to make it work. Whatever the person needs or whatever their situation is, we try to accommodate to make it work so that they feel comfortable with the process and get everything done the way they want to get done. And so I will say with what you just mentioned, sometimes the clarity call is a chance for you to see, do I even need to do a new estate plan? I might have one that actually is set up pretty well for right now. And so I don't even need to do a new estate plan. That's the time that you can talk with me during a clarity call, and then we can figure out together, do we recommend that you start a new plan, or is the one you have good? Or I usually will point out to say, okay, these are the things that I would recommend you change. These are critical, these are not, and you get to decide what's important to you.
Right. Okay.
Mhm.
Mm-hmm.
Yes, and I'm trying to see. I thought I had another. So I see someone asked if we will make this available to those who register. So yes, I will send out the link to the recording to those who registered. So definitely stay tuned for that, and you will have that to review later. I actually might put it on YouTube as well. Someone asked if we're automatically registered for next month's session. Once you register, you are registered for all the sessions. And so I'll try to remember to, I usually add you. If you don't want me to add you to my email list, definitely just email me or unsubscribe when you get a message from me. But I add everybody to the email list so that you can get updates about the next presentations and all the other goodies that I like to share. If you are on my email list, you know I like to just share whatever I think is going to be helpful to the people who are subscribed and any sometimes I even share life lessons. That's something I've been doing recently, sharing some observations about life, and I try to tie it in to estate planning, but sometimes it doesn't tie in as much. But let's see. So I want to see if anybody else had any questions. If not, then I can just kind of go spend about 10 more minutes to go through some of the slides that I blazed through when I started feeling like I was running out of time. And I'm putting the link to the YouTube channel here. So I would love if y'all would go on there, subscribe, watch a few videos, tell your friends and family about it. And also let me know what kind of information do you want me to put on there. Like any information I can share, I'm happy to share it. If I need to do a little research to get the information to you, I'm happy to do that. So definitely let me know if there are other topics that you would want me to cover on there. Let's see. So I'm gonna pull my slides back up. And if anybody else has questions while I'm doing that, then do not hesitate. And if you need to go, then y'all definitely go and have a wonderful evening. If you're in the rain like I am, if you have to go anywhere, then make sure you're careful out there. And it's just been a pleasure having all of you here joining me during this conversation. So I'm gonna go to some of the slides that I breezed through at the end and we'll go from there. If anybody has like a particular one they want to spend a little time on, we can do that. Cause I'm just here. As long as y'all here, I'm here until 8:30 at least. Well, I won't say at least, at most. I'm going at 8:30. Thank you so much for coming.
I'm still very interested in how the will versus the revocable and irrevocable trust work.
Okay.
Because I think that's kind of where I am in the process of estate planning and
Mm-hmm.
need a legal review. So the trust-based plan versus the will-based plan.
Okay, so I'm going to talk about those for a little bit, and then I think I'm gonna go back to tell some of the horror stories.
For both of them.
I know. So I'll do that. So as far as the trust-based plan versus a will-based plan, a trust-based plan, the foundation of that plan is your trust. You want your trust to cover all of the different scenarios of what happens to your property if you become incapacitated, who's in charge, does anybody have any rights to get access to your property when you're incapacitated? And then you also talk about after you've died, how do you want your assets to be distributed? And there are so many different options. You can say that these are the particular people that I want to receive particular things, or you can say that I'm going to put it all in a trust that continues after I'm gone, and then those individuals can benefit from the income. They'll receive the income from those assets, but I'm going to put somebody over the trust to manage it for their benefit. So you might have people that you don't really want to give them the property outright, but you want to put it in a trust, and then a trustee can manage that property for them and just send them a check every now and then. So that's the trust-based plan. You kind of create your world. You put the rules in place, you say what happens when, how it happens, and then you get to keep the courts out of your affairs as much as possible. There's some situations where a court might have to get involved, but you can create a scenario where everything's managed in your trust. The key thing to remember is that you must fund the assets into the trust. So I've seen too often, I don't know why this happens, and that's actually one of the horror stories that I had, where someone, a lawyer even, will create a trust, and they won't encourage the client. They won't make well, let me go back. I'm not going to blame the attorney, because sometimes the clients don't do what they're supposed to do. So you create the trust, but the client has to work with the attorney, or on their own, they have to transfer the property over into the trust. So if there's a piece of real estate, that there needs to be a new deed written out that says that now, as an individual, you are deeding your property over to the trust. Or there needs to be changes on bank accounts. There's a lot of things that need to happen to transfer the assets into your trust. Because if you don't transfer it into the trust, that trust can't control that asset. And so the story that I used to illustrate that, I had a situation where a client had a trust created, but he didn't put his real estate into the trust. I mean, he wasn't my client, but he was the person who owned the property. And when he died, his family was like, well, he has a trust. Everything's in a trust. He never had everything changed over. And so they still had to go through probate in order to get control of those assets. But the good thing was that when they went through probate, they were able to put the assets back into the trust and control the property through the trust. And in this particular situation, it was really critical that they had the trust, because this was someone who had a second marriage, and in their trust, they left their property to the first spouse and to their children. When they got married, they didn't change it, and so everything was going to now go to the new spouse. But because they had this trust, they were able to make sure that the children still got what they were supposed to get. So it was helpful to have the trust, even though initially they still had to go through probate. But if you change all the property over to the trust while you're living, then your family wouldn't have anything that they have to probate. And so that's where a trust-based plan can be helpful, because it takes it out of probate. Another thing that's helpful with a trust-based plan is when you're doing, like, some people might need to do incapacity planning. Let me see, long-term care planning. So they want to make sure that if they got to a place where they needed long-term care, they want to first be able to afford it, because it's very expensive. It can be up to $100,000 a year or more. So you want to be able to afford long-term care. And you also want to make sure that your assets that you've been working hard for all your life, that is not automatically handed over to the state after you die. Because if the state pays money for your long-term care, they're going to want to be repaid after you die. And so, especially with clients who own family properties, they don't want that family property to be sold after they're gone and the money given to pay their long-term care expenses. So they might create a special trust that holds that property and protects it from that estate recovery after they're gone. And so there are ways that you can use irrevocable trust to help with long-term care planning. If you are someone who wants to create an income for yourself or for your family, you can have charitable trusts that have certain provisions in them that can be beneficial for tax planning, but then also for income. So there's different things you might do, different types of trusts you might use as the foundation of your estate plan. Or if you would prefer to go the will route, you can still say who gets your property, who's going to be in charge. But in order for that to become effective, your family would have to go through probate court. Your executor or whoever it would be would have to go through probate court in order to get that legal authority to handle your estate and to divide everything up. So that's the main difference, is that with a trust, as long as everything is put into the trust properly, you don't have to go through probate court. But with the will, they would need to go through probate court. And it just really depends on the person. I have some clients who a will is better for them. I had a client who's 94. He wasn't really interested in having this trust created that's going to hold all his assets, because he's like, kind of at the end, as far as he understands, he's thinking he's at the end, but the way he's trucking along, you just never know. But he didn't really want to create this whole trust structure with him being, where he considers at the end of his life. So a will was fine for him, because he's like, I'm probably going to just go, and then I want my executor to come in and administer my estate. I don't want to create any extra mechanisms that they have to address. So, it just really depends on the client, what is going to make the most sense for them. Yeah, so someone said,
and you said that the trustees can actually be the beneficiaries as well.
Yes, it depends. There are situations where it does make sense to have the trustees be the beneficiary. Like, because you might have like your oldest child as your trustee, but then you want to still make sure that they get something from your estate. So you can have that situation set up. Or even with the revocable trust, you would be the person putting the property into the trust, but then you also are the person who benefits from the trust, and you're also the person who manages the trust. So in that situation, you will have yourself be a trustee and beneficiary. So there are what you can have that happen. There's some situations where for tax planning or for other purposes, you might want to have different people serve as the trustee than the people who are the beneficiaries. But again, that's something that's kind of a case-by-case situation that you would want to set up so that you accomplish the specific goals. So it's always going to be based on the person's goals. And so someone mentioned in the chat something about how a trust can be good when people have children from multiple marriages or relationships, when your spouse is not necessarily the parent of your children. That can be very helpful to reduce family conflicts, because then you're not having to go through probate court and everything is public. Like with probate court, if you have a will, you'll say, okay, I want my spouse to get the house, I want my children to get $20,000 each, or whatever you might put in that will. That becomes public. So anybody who finds out about it, they get to see what everybody has gotten. And you may not even want your children to all know that you gave who you gave things to. You might not want them to know you gave more to one child over the other. With a trust, that's a little more private. With the will, is all out there. It's public information. But with a trust, it's something that only your trustee has to know about. And if you put in your trust that you want your beneficiaries to know about it, then they can know about it as well. But if you want it to be private, then that's something that you can set up so that only the people who need to know, and people who don't need to know, they don't need to know. They don't get to know. So that's something that a trust can be beneficial in that way as well. So when with my firm, and I think it's kind of similar with other firms as well, that initial call is when you'll decide whether a will-based plan or trust-based plan is the most beneficial for you. It just depends on your individual goals, where you are in life, your assets. All of those things are used to consider to help the attorney determine which one they would recommend. But ultimately, that decision is going to be the client's, because we'll say, okay, if you want these goals, then this plan will work for these goals. If you want these other goals, this plan works for those. But you can still say, I think I just want to go with that. And so that's something that, it's kind of a hand in hand kind of thing. The attorney has a role, but the client has a role as well to decide what's going to be best for that particular client.
And how long is your holiday certificate good for?
So you can purchase through, I can't remember if it's Christmas or the end of this year, but the purchase can be made for the next few weeks. The person can use it through the end of next year. So
Okay,
that's how
great.
it's set up. So we want to encourage them to try to get it done within the next year. But we do want to give them time if they want to kind of, plan for it later. And just so y'all can have that, I'm gonna go to the slide where you can scan, or you also have the link. Thank you, Jacqueline, for your comment on the deal. Any other questions? I got about 5 more minutes. If there are any other questions, or if someone wanted to go back to a particular slide, then I can do that. Does anybody have any hesitation on estate planning? Anything that makes them feel like, oh, I know I need to do it, but I'm hesitant to get started? Anything that we can talk about that would help with that? All right. Well, I haven't seen anything pop up in the chat or anything like that. So I will say again, thank you all so much for joining me this evening. I definitely would love to get your feedback on how this was for you. I'm going to send out a survey. So if you don't mind taking a moment to answer the questions in the survey and just let me know how this presentation was helpful, if it was helpful, or things you would like me to cover in the future. And I'll make sure that we just improve each time we do it. But if I don't speak to anybody who I don't speak to before Thanksgiving, then have a happy Thanksgiving and a wonderful holiday season. Everyone take care.